Good evening and welcome to Disqualified Dads. Tonight's episode is a very, very special episode. Tonight is going to be a Q&A. We're going to have Mr. Ryan on and we're going to attempt to answer all of your family court issues, family law problems. If you've got caught up in the web of divorce and separation, you need to be here tonight. Mr. Ryan will be on shortly and we will be addressing all of your questions. But before we bring Mr. Ryan on, I've got to do a few little shout outs to a few organizations who are doing some good work out there. First and foremost, Falsely Accused Network. Mike, he's on TikTok. Go check him out. He's doing a lot of good work supporting a lot of fathers. Another chap on TikTok, MUST UK, Must UK, Stop Forced Adoption. He's doing a lot of work around that area. I'll have him on in the future as well. And he's going to be talking more about that. Also, shout out to MFSF, Ahmed Raydan. Shout out to Rangi. Rangi's getting out and about. He was in Preston today, my hometown. Shout out to you, Rangi. Equal Start, Sean Buchanan. Sean, he's doing some great work, activist, campaigner for men and boys. Also, shout out to Split the Difference, Sister Sally. She's done some brilliant work around the CMS. And shout out to Stuart Blake, Put Kids First. He's a fathers group. He's got a WhatsApp group. They support fathers. And another fathers group, Help With Hassle. It's another fathers group I'm with. So shout out to them. Now, before Mr. Ryan comes on, I just want to go over some house rules. Obviously, this is a delicate subject, family court and whatnot. It is meant to be a secret court. So once I bring you on, do not mention your ex-partner's name. Do not mention the name of any children. Ideally, do not even mention what court you're in. If you come onto the stream, you want to remain anonymous, just leave your camera off. If you want to mention your name, that's up to you. And when you're on, please just stick to the point, just ask your question, highlight your circumstance, and Mr. Ryan and myself potentially will try and answer your question best we can. Right, without further ado, let me bring on Mr. Ryan.
Hi, good evening.
How are you doing, Mr. Ryan? Long time no speak.
I'm good. Yeah, I'm in the north tonight and you're in the south. So there we go. We're covering the country between us.
Absolutely. Right, Mr. Ryan, do you want to just give us a quick little brief on the purpose of tonight and how we're going to tackle this?
Yes, sure. Good evening, everybody. And thanks for dialing in. My name's Daniel Ryan from McKenzie. We are a family law support practice. We're actually based in the Midlands, but we cover the family courts right across England. And very occasionally we get across the border into Wales. We're not solicitors, we're not barristers, we are McKenzie friends. And during the course of the evening, I'm going to talk about that in a little more detail as to how we differ from the rest of the legal profession. But we've been doing this a very long time. And in that time, we've learned an awful lot about how the family court runs, how the family court can be your friend, but also how the family court can be the enemy that is going to bring you down. And we need to be aware of all of that. So over the course of this evening, as Farouk has already mentioned, we're going to keep our eyes open for the questions that are popping up on the screen, and I'm going to try and keep my eyes on that, and Farouk's going to guide me. And then we will pick up on those questions and give you the answers as best we can. We're going to try and keep it short and sharp so I can get through as many questions as I can, because that's quite important. I want to give everybody the chance to dial into us. We're also going to talk during the course of the evening about some very specific areas. I'm going to talk about the journey that you are going to take if you're about to launch yourself into family court. Some of you may already be there and be halfway through that journey, in which case you're going to catch up with me as we go through the evening. But ultimately, when you enter family court, you're there for one reason and one reason only, and that is to try and secure an order, a court order that either gives you some rights over your children and gives you some contact arrangement over your children, or resolves your finances in the case of a divorce. And we're going to explore all of those this evening, and all of those little tangents and alleyways that go off that central route, such as non-molestation, domestic abuse, our mums favoured in family court, our dads favoured in family court. We're going to explore all of that this evening. That's where we're going to go.
Right, Mr. Ryan, I just want to kick this off straight away. Franco's Pizza in the comments, he said, why would someone use you for his family law, basically, from what I understand? Why would someone use a McKenzie for family law? Just a quick brief and why we should avoid and stay away from solicitors ultimately? Quick, just answer to that.
Short and sharp. Why do people choose a McKenzie friend? They choose a McKenzie friend primarily because of a cost, primarily because they don't have the budget in order to go and take on board a solicitor, because solicitors are expensive. They serve a value in this country, but they are expensive. So people take on a McKenzie friend as an alternative to a solicitor. And later on in the evening, we're going to talk about the difference between a good McKenzie friend and a bad one. The one that's going to serve you and the one that's going to bring you down.
Yeah, Franco, I just want to say my personal view is straight from the streets. Avoid them. They're there to fleece you. They're there to make money off your misery, and they're there to make money from your family breakdown. The whole system is designed to generate money out of misery. Hence, avoid them. Don't feed the monster. Go get a decent McKenzie. Right, Mr. Ryan, shall we progress? I've placed the, by the way, listen, everyone in the chat, the link is now in the chat. If you want to come on live to ask your question, just click on the link and I'll bring you in and out one by one. Right, Mr. Ryan, shall we proceed a little bit further?
Yeah, let's go a little bit. Hang on, Franco's come back with a comment. I'm just going to read that. I've been in this situation before, and the best way to solve the family situation is to step back. If you mean by that, Franco, that in order to avoid conflict and move yourself away from a situation, there's a view for that. The family court, provided you are navigated, provided that you have a decent Sherpa who's going to guide you through it, the family court can work for you. But there are a lot of pitfalls and a lot of potholes along the way that you need to try and avoid. So I take your point that sometimes it's better just to step away and hope that it'll come back and hope it'll be resolved in the years ahead. Karma, that's your comment, and you're absolutely right. Maybe we wait for karma, but maybe we do something a little bit more productive and we engage with the family court, and that's what we're here to do on your behalf.
Right, Dan, before we proceed, there's a guy just made another comment. I know this chap is, I believe he's in a lot of pain. So look, I'm just going to read his comment out. I won't mention his name. I'll just read his comment out. I have indirect contact, did the courses which Judge and CAFCAS was okay with, but updated CAFCAS report stated I was frustrated and she's not even recommending me being on the birth certificate. Now, he's jumped through hoops. When a father has jumped through hoops, he's done what he can. He's accepted and taken the label of an abuser, done the courses, and then still this level of oppression where unfortunately mum can even still put roadblocks in his way to have some contact after years. I mean, what do you say to that?
It's difficult because there are two issues there. Obviously, Majid has raised two issues. There's the issue of being on the birth certificate, and there's the issue of that you believe family court is against you and CAFCAS is supporting the other party, in this case, in Majid's case, mother. Let's deal with the birth certificate very quickly. There are lots of people in this country who have children together, and then mother goes off to register the birth and chooses not to put father on the birth certificate. The reason she does that, whilst I have a view on it, but the reason she does that is primarily in order to try and remove his parental responsibility, try and remove his legal right to be involved with that child. You can go to court and endeavour to secure having your parental responsibility restored. It's a difficult process. It's not an easy process, but that is essentially what's being referenced there in terms of birth certificate. But let's go back to frustration. CAFCAS are unusual animals in that they will sit and they will listen to mum and they will listen to dad, and having done that, they draw an opinion like all of us, and that opinion isn't necessarily the opinion we would like. The problem is dad in this instance is sat with CAFCAS and he's expressing his frustration about the fact that obviously he feels the process is against him. He feels the fact that he's being obstructed and stopped from seeing his child and stopped from having a reasonable shout in the family court. That's his view. That's what he's trying to do. And maybe he's expressing that in a way that's quite animated. From CAFCAS's point of view, what they're watching is they're watching a man in front of them get angry. And they're watching a man get angry. He's not frustrated in their opinion. He's angry. And the problem with anger is it's misinterpreted. So they go into court with their report and say, yeah, dad's very angry. He's a very angry man. And then suddenly from that, we've then got suggestions and insinuations that that's going to impact on the children, it's going to impact on mother. It's difficult. There is a way to manage your relationship with CAFCAS. You have to try and keep CAFCAS on side as your friend. And I appreciate that is difficult to do because they start the process potentially by being against you, but you have to try and turn them. And being angry and frustrated and venting to the CAFCAS officer is a way that's just invariably not going to work for you.
All right, Mr. Ryan, a few more comments coming in. We'll just touch up on a few more comments before we proceed with the first slide. The latest comment, once the final court is issued, I presume court order is issued, can mum change the child name or surname?
No. The answer is this. A court order is required in order to change the name of your child. It's referred to as a specific issue order, and you have to make it as part of the application. So if in an instance where mother wants to change the child's surname to her own, because she's changing her own surname perhaps back to a maiden name if she's been married, she has to get permission from the court in order to do that. If she chooses to do that through deed poll, which is the other way forward that she can do it, she's required to have the permission of both parents, so mother and father. Mother can't just off her own bat decide she wants to change the child name just because it no longer suits her to carry what I assume is father's surname. So yes, that's the issue there. It's not something that people have the right to do on their own. They have to have a specific court direction in order to do it.
Okay, perfect. Shall we, until more questions come in and until people connect onto the live stream, Mr. Ryan, do you want to proceed with maybe your first slide that you've got prepared?
Yeah, we're going to do that.
Entering the system.
Yeah, let's pick up the C100 if we can, please, Brooke.
Right.
Okay, so this is the start of your journey. The C100, just click it forward a few bit. This is the start of your journey. The C100 is the first application form that you are going to complete in order to get yourself into family court. It is a document that is recognised in every family court in England and Wales. It's a very comprehensive document. It runs through about 25, 27 pages, something of that nature, and it requires you to detail who you are, who it is that you want to take into court with you, and also the details, obviously, of the children. And ultimately, it requires you to tell the court, what is it you are trying to do? Is it that you are trying to flag to the court that there is a domestic abuse issue? Is it that you are trying to just get some arrangement, some contact framework between you and mother, or indeed father, in order to be able to see the children because you just can't agree it between you? One of the questions I get asked quite often is, do reasonable people go to family court? And the reality is not really, because otherwise you wouldn't have gone to court, you'd have sorted it out outside. So the C100 is the start of your journey. It's the first story that you fulfill. You write this page in order to tell the court at the outset, what is it I am trying to achieve, and give them a little bit of background history. There is a question in here where it asks you to essentially tell the court what it is that you're trying to achieve in terms of, why am I here? There's domestic abuse issues. There are issues that we just cannot agree on the practicalities of child contact. But before your journey starts, there is an area that we call mediation, also referred to as a MIAM, M-I-A-M. Every person who decides they want to go into family court must start their journey by entertaining mediation between you and the other person. Mediation is required in order, because the court wants you to see whether you can actually sort yourself out without taking up court time. So we do that through mediation. Now, there are grounds whereby you can bypass, where you are exempt from mediation. And those grounds are invariably domestic abuse. If one party or the other is going to allege domestic abuse, then mediation becomes inappropriate, and you will be issued with a certificate, which we refer to as a MIAM, M-I-A-M. You'll be issued with a MIAM, and you submit that to court at the same time as your C100, in order that the court is aware that you have tried. And you'll notice, as we're looking through these pages that are popping up on your screen now, it's asking you to indicate why it is that you believe that mediation is inappropriate. And often it is about the world of domestic abuse. So we're just watching the screens pop now. Here as you see, there's lots of questions being asked. And eventually it gets to a point where it starts asking questions like, does there need to be safeguarding in place in family court? The family court is quite sensitive to the issue of one party potentially being afraid of the other, one party potentially being anxious, nervous, worried, whatever phrase you want to apply to the other. The court is conscious to that, and the court will accommodate that by the use of physical screens in court so that the two parties can't see each other, by the use of separate waiting rooms so they don't see each other while you're waiting to go into the court, the use of separate toilets if necessary. It really does depend on the degree of animosity between the two parties. But the court will accommodate that. And within the C100, apart from telling your story about why it is you're here and what it is you're trying to achieve, it also gives you the opportunity just to indicate to the court that you wish to have special measures. That's what they're referred to as. You wish to have special measures in place to safeguard you, or indeed safeguard the other party from what it is, the issues between you, the anxieties between you. There is a fee for placing a C100 into court. That fee currently today is £232. That is the court fee. Obviously, on top of that, if you are having the C100 prepared for you by a solicitor or indeed by a McKenzie friend, then there will be a fee on top for those people as well, unless you manage to find one who works for free. The document is then submitted. You do have the opportunity to have the court fees waived, i.e. you don't pay them. There's a document that you get to fill out. We'll provide the details as and when it becomes appropriate. There's a document you can fill out in order to have the fees waived. And essentially, it is a document whereby you demonstrate to the court that you cannot afford to make the payment. You cannot afford to make the £232 payment. So that's a real issue. You need to be aware of it because, as I say, it's quite a small audience who can have the fees waived. Most people have to pay them. But the C100, we're just letting the pages roll under. As you can see, it's quite a lengthy document. So we've only just got to the page where it's asking you to provide your details. Now, you have the opportunity, if you are anxious, you have the opportunity to withhold your details. Obviously not your name, but you have the opportunity to withhold your address. You have the opportunity to withhold your phone number, withhold your email address. And the reason you do that is a copy of this document, once it's been processed by the court, is going to go to the other party. So they're going to see what it is that you've written. So if you've moved out of the property and they currently don't know where you live, either with the children or whatever, you have the opportunity to withhold that information by completing a document that referred to as a C8. So we're filling in the document. You then have to fill in the details for the other party. And eventually we get to the stage where, there you go, you get to actually sign it and sign the document off and send it off into court. So quite lengthy, relatively straightforward, but as with all documents that get submitted into a legal forum, there are tricks of the trade in order to do it correctly so that you don't catch yourself out. There are things you say at the early stage. There are things you don't say at the early stage, because whilst you want to tell your story, you don't want to give all the details away, because what is going to happen is this document is going to go to the other party and you're going to inform them of your position, but also this document is going to go to CAFCAS. And that document will be used by CAFCAS as the basis of their first conversation with you. So I always urge people to tread carefully in what it is that we say.
Right, Mr. Ryan, can we clear up? So there's some questions in the comments now. There's a question from Tim Wiltshire. How do you get a fact-finding reheard if you have been given permission by the High Court to do so, but the district judge who the case is reserved to refuses to give you leave to appeal? I don't know if you can see that comment, but do you want to?
Hang on, I'm just having that rolled down. Oh, there we go. Okay, so
Tim Wiltshire, yeah.
Okay, so hi Tim. So how can you get a fact-finding reheard if you've been given permission by the High Court to do so, but the district judge who heard the case refuses to give you leave to appeal? Right, okay. There is a process for appeal, and because without knowing the details of yours, Tim, I don't know where you are on it. A fact find takes place in the family court. A fact find is essentially a trial, in inverted commas, that takes place to explore the allegations that have been made by one party against the other. That fact find will release a judgment. That judgment is the judge's decision on whether he or she believes that those allegations are true. They don't have to believe they're all true. It can often be a mix. It usually is. So Tim is making a comment about appealing that, so challenging that fact find. The process ordinarily for appeal, and as I say, unfortunately, I don't know Tim's details, so I'm going to have to second guess up to a point. The process for ordinarily for appeal is you make your first appeal to the judge who made the initial order, the initial judgment, and you ask him or her for permission to appeal. What then happens is, assuming that you are granted, although honestly it doesn't matter whether you're granted or not, because you have the right of appeal. So whether they refuse or not, you have to go through that process. Then the first instance of your appeal is it is heard by the most senior judge in that court, in the family court where your fact find took place. They hear it in the first instance. They either agree with your appeal and grant it, or they don't agree with your appeal and they refuse it. It's A or B. Either way, you then have the opportunity to go to High Court, which would appear to be what Tim has done. The journey of how Tim got to High Court, we don't know, because obviously we don't know Tim's details. But Tim is suggesting that he has now been given permission by the High Court. So by virtue of that, I presume that Tim's appeal in High Court was successful, which means the High Court have said to him, we are granting you permission to have your fact-finding reheard. Now, Tim should have a court document that tells that, that says that, and he needs to submit that court document back to the family court who did the original fact-find. There we go. Thank you, Tim. Tim just said that's correct. So we need to submit that original court document, the High Court document, Tim. You need to send that back to the family court to advise them that you now have been given leave to have that fact find, the original fact find, set aside in order that you can now have it reheard. They have no choice. Whether the district judge wants to do it or not is irrelevant. The High Court have told you, they have granted you, I haven't read the order, so I'm second guessing, but the High Court has granted you the right to have that fact find reheard. Submit it back to the court that did it originally, and just tell them it's got to happen.
Right. Mr. Wright, next comment was from, are you done with that question, yeah?
Yeah, okay with that. Yeah. Obviously, if Tim wants to talk to us more specifically, I presume we're going to publish our email at some point, and we're welcome to sort of take an email inquiry on that.
Right, okay. Right, listen, there's someone that's connected to the stream. To the person who's connected to the stream, until you turn your mic on, at least, I can't bring you on. So switch your mic on, then I'll have the facility to bring you on, whoever that is that's connected to the stream. Right, next comment, Mr. Ryan. What age can the child be given the court documents of mum's allegations? Do you recommend to do this, or is that manipulation? I don't know if it's after Tim's original question.
Okay, all right. Okay, documents, children seeing documents. The court's stance is that the children, regardless of their age, and because you're in family court, they're under the age of 16. So children under the age of 16 are not allowed to see court documents. It is against the law. It is as simple as that. The court doesn't believe it's appropriate, and as I say, it is against the processes and procedures of the court for you to allow children to see it. Now, having said that, lots of people do. I don't agree with it. I think you're pulling your children into a set of proceedings where they don't need to be, and I think you are potentially traumatizing your children. So the answer to the question, do I think it's manipulation? Yes, I do. If you are sharing with your children the allegations that are being made against you and indirectly involving them, if you are sharing that with your children, then unfortunately you are manipulating your children, and that's inappropriate. Your children should be maintained to be as innocent as they possibly can be, regardless of the war that is going on around them. So keep children off court documents. There's no requirement for them to see them. As and when the court deems it appropriate for children to be involved, the court will appoint a guardian, and it's referred to as a section 16(4). So the court will appoint a guardian to work specifically and directly with those children in order to involve them in the proceedings. Until that happens, children, stay out.
Right, next questions from the same fellow. Can mum apply for the child to have a different passport from the country they were born in?
If mum is trying to get residency somewhere else, or mum, I'm assuming from this question that mum already has potentially dual residency or dual passports. Can mum apply for a passport for the child? Yes. Does mum require the permission of father? Yes. All passport applications require both parents, particularly under the age of 16, if the child is, require both parents to be involved in that process. If you are applying into, and purely because I've just done this one very recently, if you're applying into what was formerly Eastern European countries, so into Poland, Romania, the Ukraine, Czech up to a point, it is definitely a requirement for mother and father to both sign the application documents.
Right, one more question from Kashi, from the same fellow. Paternal responsibility or parental responsibility is a nice phrase used in the industry. What if you are not married? Can dad actually get a shared custody order?
Absolutely. It's the marriage when we're dealing with child proceedings, whether you are married or not is irrelevant. Marriage is an issue that you fight about outside of a child matter. Child matter doesn't care what the basis of the relationship is. They care that there is a mother and there is a father. So it's perfectly feasible for mum and dad to both get a shared care custody order, shared care arrangement, to jointly look after their child. Marriage is not relevant to that conversation.
Right, quick reminder to everyone in the chat, if you want to join the stream, the link is in the chat, but when you join that link, you have to have at least your mic on. That'll then give me the facility to bring you on. So if you do join the stream, you have your mic on, so then I can bring you in. Right, next question. My ex made 3 divorce applications. The court accepted 3 times applications. We have both signed all 3 divorce applications, and my ex-wife made all 3 applications, and I don't know why she made 3 applications. Does that make any sense?
That doesn't make a great deal of sense, because unfortunately, Emran, I also have absolutely no idea why your former wife would make 3 divorce applications. No, I need a bit more detail on that before I could comment on that, to be honest.
Yeah, so listen, Imran, can you just give us a bit more context around your question? We'll pick it up a bit later. Right, next question. If I had a final order, can I reapply to vary it based on 3 issues? 1, change of circumstances. 2, the final order not being as both me and mum have different interpretation. And 3, some breaches of order, I'm presuming.
If your child arrangement order is not working for whatever reason, whether it be a breach or whether it be the fact that circumstances have changed or whether it be the fact that one party or the other is being obstructed, if your child arrangement order is not working, you have the right to take it back to court, to family court, under a variation application. Right. A variation application is completed in the same way as you complete a C100. In fact, it's the same document. And you tell the court, I've got an arrangement, it's not working for A, B, C, D, and E, and I need to bring it back into court and get the court to adjudicate how it is that we fix this and make it work. Very straightforward.
Right, gotcha. Right, to the man from Wales, if you want to join the stream again, just come back in, click on that link, just leave your mic on, and I'll be able to bring you on. Right, shout out to Sweet Assassin. Thank you for supporting. Right, question again from Imran. So Imran's got more to his case. Now the judge has said there are 2 other applications that need to be withdrawn. In other words, pay to have it withdrawn. Is it not the fault of the court that they have accepted 3 applications?
Potentially it is. Should we just drop that C100 off the screen?
Oh, yes, sorry, my bad. Yes.
Potentially it is. I say, unfortunately, because we don't know the details, Emran. I mean, if the court has accepted 3 applications, it doesn't matter whether it's divorce or whatever they've accepted them for. But if the court has accepted 3 applications, and I assume that those applications are probably for a financial matter, because the dissolution of marriage doesn't go into a court. That's an online mechanism. So I assume it's a financial matter. It seems very odd, unless mother has, and I'm assuming it's a mother, unless mother or wife has tried to put that into different courts for reasons best known to her, in which case those courts wouldn't be aware of what's happening elsewhere. Then possibly there would be a situation where a couple of applications, or 3 applications in this instance, would have been taken. Is it the court's fault? That we don't know, because I don't know the circumstances. If they've gone all into exactly the same court and the court has accepted all 3 applications and fees have been paid on all 3 applications, then that's the court's fault. That's a mistake. That's a mistake, because the moment the court creates a case against a set of parties, if another application comes in with the same two parties on, the court should pick that up straight away. So that does sound like some sort of mistake has gone on there. But again, obviously, we're not overly sure of the details. Then I'm just reading your comment now, which needs to be, in other words, pay to have it withdrawn. There's never a requirement for you to pay to have a court order withdrawn or a court application withdrawn. You make the original application, you pay your fee. If you suddenly decide you don't want to do it for whatever reason, you just contact the court and withdraw and say, I don't wish to progress this any further. Unfortunately, you're not going to get your fee back, but you can withdraw at any time in an order, in any set of proceedings, regardless of where they are in terms of the process. But that's a little confusing. As I say, 3 applications, particularly 3 applications to the same court, is very odd.
Yes, Imran, I know what you're worried about. You're worried about spending money. Don't give them nothing. Don't spend any money. I know what you're worried about. Right, next one, Mr. Ryan. What do you need to do to get a order revoked? Ex got an order allowing her to move to London, but she isn't moving anymore, but keep using that order against me when she isn't happy with me.
Okay, that again, it's a variation. You need to make a variation application and go back into court and say, we've got this order in place, it's not working because we're not going to use it, or whatever your circumstances are, and I need that order changing or removing. So that's very straightforward.
Right, question from someone else here. I won't say their names because I don't know if they want their names out there or not. So I'm just going to read the comments, read the questions out. Can a court recital stating that the mum helped the father obtain parental responsibility considered as actual parental responsibility?
Court recital stating that mum helped the father obtain parental responsibility. So I'm assuming from that father is not on the birth certificate, because if a father is on the birth certificate, he automatically and legally has parental responsibility. So we're assuming that father hasn't got parental responsibility, and the court has said that father and mother, according to reading between the lines, that father and mother have got to work together in order to create parental responsibility. What that requires is for father and mother to recontact the births, deaths and marriages registrar and have the birth certificate amended in order to add father to it. If the court had wanted to award father, which they have the power, if they wanted to award father parental responsibility, it wouldn't be in a recital, it would be an order. Let's just explain the difference very quickly. You'll find when you get an order from court that there are, apart from a significant amount of words on it, some of those comments on there, some of the statements on an order are referred to as recitals, and it will say on the order invariably, the recitals are, and it is recorded that, and it is recorded that, and it is recorded that. Once they have taken place, there's then a second part of the order, where it says the court directs that. Everything underneath the words "and the court directs that" is law, is backed up by a legal bond that says that you must comply with those orders. You must comply with whatever is said. Anything that is in a recital, so anything that is before the comment "and the court directs," is not law. It is a promise. It is an indication. It is a statement of goodwill. So if a court makes a recital, in this instance saying that mother and father will work together to achieve parental responsibility, that is the court asking mother and father to promise to the court that they will do it. Here's the problem with promises. People don't fulfill them. We need to chase an order. We need to chase a direction from the court, not a recital.
Right, okay. Are you done on that question, Mr. Ryan?
Yeah.
Okay, right. Next one. I won't mention a name.
Yeah.
Someone's just stated, I have a non-molestation order and have taken a undertaking. I made a mistake in replying to my ex's email back and forth. It has resulted in the police coming and want to have an interview with breach of non-molestation order. Any advice for that, chap?
Difficult one. I mean, if you've taken an undertaking, the reality is that an undertaking, well, let's explore the differences. Now, you say you've got an undertaking and you haven't got a non-molestation. An undertaking is a promise to the court that you will conduct yourself in a certain way, that you'll behave in a certain way. A non-molestation order is something fundamentally different. A non-molestation order is a direction from the court that you will conduct yourself in a certain way. So we're back to directions and recitals. Non-molestation order is a direction. You will not go within 100 meters. You will not email her. You will not talk about her on social media. You will not contact her in the street. You will not go anywhere where you know she's going to be. That are directions that sit within a non-molestation order. An undertaking is where you promise, there is no non-molestation order, where you promise to the court and to the other party that you will conduct yourself in a certain way. So, your situation, I surmise that in your undertaking, you weren't supposed to contact her. And she's emailed you and you've replied. How many people fall into that trap? My suggestion is that when you do eventually go to see the police and have your interview, you take your undertaking with you, a physical copy of your undertaking, and you advise the police, I do not have a non-molestation order. I have an undertaking, which is not the same thing, which is not a legally binding document, and I made a mistake. I was engaging. I have no idea what the emails are, so I don't know whether they're insulting or not, or whether you're just trying to be helpful. But I was engaging in an email exchange, and I appreciate that was a mistake. The police will have very limited opportunity to do much about that, apart from give you a slap on the wrist.
Okay, right. I'm going to move forward. There's a lot of comments there. I'll try and get to those that look like questions. Is it correct that once the final issue is ordered, the goalposts move and the order moves in criminal law and no longer family law? Dad loses further contact time. I'll read it out again, just it seems a bit confusing. Is it correct that once the final issue is ordered, the goalposts move and the order moves in criminal law and no longer family law? Dad loses further contact time. Does that make sense?
It does make sense. When you at the end of your proceedings in family law, you will receive an order. You'll receive a court order that tells you what the framework of contact, and I'm assuming we're talking about children, what the framework of contact between you and your children and the other party, so mum or dad, what that framework looks like for the years ahead. Sometimes, once you've put that framework in place, one party or the other is not happy with it. And consequently, they will then start to pursue, realizing that family law is now done, they will now start to pursue allegations outside the family court. They will start to involve the police. They will start to contact the police and make numerous, often new, often never heard of before, allegations about how dreadful you are as a human being. That is because they're not satisfied with what happened in family court, because they didn't get the outcome they wanted. So sometimes, sadly, the matter does start to drift outside family law and drift into criminal law. But I say this, the police, and whilst I have not the best opinion, but the police are conscious of the fact that two parties who have been in family law proceedings invariably don't like each other. The police are conscious of the fact that one party will often make allegations against the other just because they are not happy with how it is that the matter is being dealt with in family court, because they're not happy with the fact that the party that they are aiming their acrimony at is not on their knees being beaten with a stick by a judge in family court. Consequently, they decide to involve the police to see if they can escalate the matter. It's sad, it's unfortunate, but we live in a real world.
Right, quick question again. How does the judge make the final decision? Can it be challenged?
The judge makes a final decision in a child matter based upon everything they have heard and everything they have been told. So both parties at that final hearing, both parties will have the opportunity to give their view. Both parties will have the opportunity to bring in examples of what has happened previously, possibly in previous cases. And that's about using either, dare I say, a decent solicitor or a decent McKenzie friend who understands family law and has family law precedent. So bringing in some examples to the judge that says, look, previously, when this set of circumstances presented themselves, this is what happened. Judge makes a decision. He makes a decision based on a number of factors. What he heard, what you said. He bases it on the fact that he has life experience and we're assuming it's a he judge. He has life experience, and he applies that life experience to the circumstances in front of him. He also has legal experience, obviously a vast amount of it, and he applies that. So he has his own set of precedents. If I am in preparing for a final hearing, and I present to the judge a written submission document that says, this is what's happened previously, Judge, when this set of circumstances, most of that he's already going to know, because he's already done the same research. He knows where this is going to end. Judge makes a decision. Now, let's go to the second part of that question. Can it be challenged? Of course it can. Every decision in family court is available to be challenged. You have the right of appeal to every decision that is made in family court. There is another part to that question, and the other part to that question is it right? Is it appropriate? Is it going to get you anywhere if you appeal? And that's a question that is driven by the set of circumstances of that case. That is a question that is driven by how the other side are reacting. And it's a question that can only be dealt with on the day with that particular case in front of us as to whether we decide whether appeal is appropriate or not. We take a lot of matters to appeal here at McKenzie for Carve, and I'll use us specifically. We take a lot of matters to appeal. But also, I have to say, I spend a lot of time talking my clients out of appeal. And the reason I do that is very simple. Number one, they're expensive. Number two, the likelihood of you actually winning an appeal is small. Appeals are not granted often. And the further acrimony that appeals present often is not worth it. Often we need to find an alternative approach and see if we can engage and reach out to the other party and find some middle ground. You can't continue. As adults, we can fight all our lives if we want to. But a childhood is at most 14, 15 years long, at most. At that point, suddenly they've got an opinion of their own. You can spend 14, 15 years fighting with the other party and destroying that childhood, or you can accept the fact that you may have lost a few battles, but you can find some middle ground and ensure that the childhood was worth having. That's the approach we take.
Right, Mr. Ryan, if I am named on the birth certificate, but I don't have a copy, can I request this from the relevant registrar?
You can indeed. Births, Deaths and Marriages Registrar. It's on the government.co.uk, I think it is, website. I can't remember what the fee is, but yeah, there's a small fee and you can request a copy and they'll send it to you.
Right, next question. Let me jump through some of these. I am the main carer 3 nights a week and alternate weekends, but ex-partner wants to reverse that and I have new proceedings against me. How can I maintain lives with order that I presume he's got?
Yeah, okay. Lives with, let's just for those who aren't familiar, I'm going to take my jacket off now. It's getting warm in here, Farouk.
Yeah, things are getting heated. We're getting into this. We're now warmed up. That's it.
Yeah,
it's 31 here.
Yeah, let's explore what a live with order is. So when you get into court, and you get to that final set of proceedings, the judge is going to make some decisions on what and how it is those children are going to live the rest of their childhood with you and your former partner. And they are going to make an order. And they have a number of options available to them as to what that order looks like. One of them is what we call a lives with, spend time with order. What that means is one parent, be it mum or be it dad, is the lives with parent. So the children live with mum and they spend time with dad. Does that lessen dad's parental responsibility? Absolutely not. All it is the court setting a boundary that says the primary carer on a day-to-day basis of these children is mum in that instance. So that's a live with order. You can also have, they don't often use this phrasing, but we'll use it occasionally, a lives with order, which is the same as a shared care order, whereby both parents are equal in terms of those children. Now, lots of people make the mistake, and I'm going to come back to your question, Zaid, but lots of people make the mistake of assuming that shared care means that in every 14 days, one parent gets 7 days and the other parent gets 7 days, because that's shared. It's not like that, because practicality doesn't work like that. Children's diaries, children's school time, etc., doesn't often allow two parents to sort of split the time as equally as that. So what there has to be is an element of practicality around a shared care order or around a lives with order, whereby one parent accepts the fact that the priority for those children is to go to school, and that is just easier to happen from one parent than it is from the other. So if you have a lives with order the mother is trying to challenge because she's not happy with it, going back to your original question, so if you have a lives with order the mother's trying to challenge, then unfortunately you are going to end up back in family court, I would suggest, and we are going to end up looking at the arrangement, and mother is going to make her argument as to why it is it's not working, and you are going to make yours, and then a judge is going to make a decision based upon an opinion from CAFCAS. Currently, you're suggesting that you're the main carer 3 nights a week and alternate weekends. So that means that is as close to shared care as sensibly, we're ever going to see, because you're effectively picking up, what's that, 3, 6, 8? Yeah, so you're picking up 8 or 9 nights in every 14. So that's a reasonable slug. The court gave you that pattern because they had a confidence that you and the other parent were suitable and capable of managing that arrangement. If one parent is now wanting to take that back to court, go back to court, argue the corner, and if justice is on your side, if fairness is on your side, and there are no circumstances that we're not aware of this evening while we're just reading your question at face value, you'll leave with what you came in with.
Right, there's 33 of you on this stream. Please hit the like button. Please hit the like. Right, next one, Dan, jump straight into it.
Yep.
How long does it take for her to take me to court to get the judge to force me to sell the house, which is in joint name? How long will it take from the day she applies to when I need to sell the house?
Okie doke. So we're into the world of financial affairs settlement in divorce. The answer to the question is, how long is a piece of string? The process is, there is an application which goes in under a Form A into court to say that you want to resolve the financial matter. It then, unfortunately, boils down to how complicated your circumstances are, as to how many hearings you're going to have, and I'll talk about time lapse in a minute, as to how many hearings you're going to have before you get to the stage where a judge possibly, and it's not guaranteed, or a judge possibly orders that the house needs to be sold. Now, let's talk about time lapse. Currently, on average, in court, from the date of application to the date of the first hearing, in most courts in England and Wales, there is at least a 3-month lapse before that happens, before you see that first hearing. So we're already 3 months in. That first hearing, very little happens. Doesn't matter whether we're in a child matter or a divorce matter. Very little happens because all we're doing is scene setting. So we've now got to go to a second hearing. That second hearing potentially is another 3 or 4 months away. We are now 6 or 7 months out from the start of this particular race. At that second hearing, the judge has asked you to bring a set of information, what we call a disclosure. So you're disclosing all of your assets, you're disclosing what it is you're trying to achieve. The judge will then sit and read that. And at that stage, if it is straightforward, the judge may say, and the judge believes that both parties are being transparent, the judge may say, well, okay, we could deal with this now and then. And at that point, he may say, well, it seems obvious to me that the sensible thing to do is to sell the family home so that both parties can take a sum of money out of it. That could happen at the second hearing. If the circumstances are more complicated, if the judge is not comfortable with the information he has received, and he doesn't believe he's got enough to have a clear and transparent view of circumstances or of your financial affairs, he will move it to a third hearing. Another 3 months goes past. So to answer the question, how long does it take before someone's going to force you to sell your house? It really does boil down to your circumstances. The average financial matter in the UK currently is between 12 and 18 months to resolve. That is the average, but average is a horrible word because, there are very few cases that we can actually apply average to. Every case has its own personal factor. But hopefully that gives you some idea. As I say, it's not guaranteed that a judge will force you to sell the house. Judges are not happy about forcing parties in divorce financial matters to do anything. The judge would rather those parties arrive at a conclusion themselves and he just signs it off. But ultimately, in order to divide you up financially and legally, if that requires a house to be sold, then he will make the order for a house to be sold.
Well, I think going forward, one day in the future, Dan, maybe we could just do a stream purely on financial order, all the options, and just to cover all angles, just put information out, because I think that's a very strong sticking point, especially for fathers, because they seem to end up losing more. So we can put some info and put some game out there how they can hustle and survive and save some money, hopefully, there in the future. Right, next one. Regarding the court recital question, if the mother, I think, is refusing to cooperate regarding the parental responsibility, what are the options?
If assuming that the proceedings are still, because obviously this is the question where it was that the mother had been told within a recital that she had to assist father to get parental responsibility.
Okay.
If the proceedings are still ongoing, then obviously at the next hearing, you bring up with the judge or with the magistrates, whoever you're facing, to say, we had this recital, mother's done nothing about it. Mother is blocking me from doing anything about it. The judge or the magistrates potentially then will say, well, that's fine. Okay, what we're going to do now is we're going to move this from a recital to a direction. So we're going to give you no choice, mother. You have to do this. So that is your option if proceedings are ongoing. If proceedings have ended and you have a final order and there was a recital in that final order about parental responsibility, unfortunately, proceedings have ended. So the only way you can tackle that issue is to restart proceedings with a fresh application and go back to court and fight again. And I appreciate that's hideously frustrating and also potentially hideously expensive. But the downside of recitals.
Right, okay. Next question. What if the child decides they want to have more overnight stays with the non-resident parent, even though the court order states, example, 2 nights per week, or wants more extra holidays? Does that make sense?
Yeah, that makes sense. Okay, so final child arrangement order gives you a framework, and that framework says that you spend 2 nights a week with dad, 5 nights a week with mum, or whatever it says, and you alternate Christmas and you alternate Eid, and you talk about and you carve up the summer holidays, etc. That framework is not finite. There is always a comment somewhere in that framework that says the parents can do more. So the parents can adjust this framework in order that the child gets more time with the parent who currently is perhaps getting less time with the child. But I'm just reading this question. Obviously, this question says, what if the child decides? Okay, so when do children let's talk about children's legality. In this country, under the Child Act 1989, children of the age of 10 or older have a legal voice, which means that they can ask to be heard by the family court. Does that happen? Rarely, but the option is there. What happens socially in this country, societally in this country, is that children from the age, because unfortunately children are growing up faster and faster year on year, children of the age of sort of 12 or 13 suddenly are now forming their own opinions and starting to vote with their feet as to what it is they want to do. How much time I want to spend with mum, how much time I want to spend with dad. I am making that decision. That boils down to mum and dad to try and parent it between them, obviously, to ensure that the child is safe. But if the question is, does a child have the legal right to decide that they want to have more time with one parent or the other? Yes, they do, because I say children have a voice from the age of 10. So a child of sort of 12 or 13 years old can arguably tell one parent that I want to spend more time with the other parent. If the parent declines, refuses for that to happen, then obviously the parent who ultimately is losing out as a result of that needs to take the matter back to court and say to Kafkas, look, you need to talk to the child. She or he wants this to happen. I'm trying to support it, and we're being blocked by the other side.
Right, next question, Mr. Ryan. How much does child benefit affect who a child lives with? I've let my partner claim as I earn more than her. Any insights into that?
In terms of the family court does not care one iota about child benefit or child maintenance, which maybe is a subject that we'll come on to. But the court has no jurisdiction over child benefit or child maintenance. Consequently, it makes no difference at all to the court who is getting the child benefit. They don't care. They don't ask. They don't need to know.
Yeah, I think general rule of child benefit is mum claims it, dad pays it back if he earns over 50k. That's what happens ultimately.
Yeah, I don't disagree with that.
Right, next question. What happens with schooling? Mum refuses contact, etc. How do you get to see school reports? What if one parent wants to send a child to a private school? Does dad have any say?
The whole issue of education is always a sticky one, and it's an issue that I always encourage. If there's going to be a difference of opinion, that we need to bring education up within the proceedings to make sure that it goes the way that we want it to go, and both parents have the opportunity to share their view on it. Private schooling is wonderful. It's a wonderful opportunity if you can give that to your child. Obviously, there is a massive cost to private schooling in this country. So that's a conversation that the two parents need to have. And if they need to have that in a courtroom because they know they're not going to agree, then bring it into the child proceedings. School reports, separate issue, which is also mentioned in that question. As both parents have parental responsibility, which means the school is legally obligated, just as the doctor, just as the dentist, they are legally obligated to provide both parents with sets of reports, with medical records, etc., because both parents are legally entitled to know what's going on.
Right, okay. I'm going to read out a comment. I don't think this is a question, but I'll just read it out as I put it in the chat. I don't have an order, but they have lived with me nearly a year since we separated. Next one, how long will it take for the undertaking for me to receive? Court hearing was 25th of March.
Okay, court hearing on the 25th of March really does depend on which court you're in, because some of the courts are quite slick and quite efficient in terms of how they process. Some of the courts are diabolical, and I make that comment very openly. The London courts are hideously slow. That's a symptom of congestion. The northern courts tend to be a little bit better. So I could give you a better estimate, Ali, if you wanted to share with me which court you'd been in for the hearing. I could probably tell you when you're going to get your order.
Mr. Ryan, I'll keep reading back, just trying to avoid using any names because some of these people don't want to send a chat, but don't want their names out there, just keep the names low key. Next question. I have unreasonable orders against me in Scottish court that I can't comply with in practice. I pleaded with the court that it can't be complied with, but the judge was ignorant, so I fled Scotland.
Right, okay. Problem we have, Scottish law is different from English.
And his question is, can it catch up with me in England? That's follow up on his question.
Okay, if you have an order in Scottish court, regardless whether it's a criminal order or a family order, to be honest, if you have an order against you in Scottish court, that order doesn't disappear just because you've crossed the border. The order follows you, unfortunately. So we don't know what that order is, but yeah, unfortunately, the order does follow you. But in terms of family law is different in Scotland to England and Wales. It's managed in a slightly different way. It's adjudicated in a slightly different way. So it's not an area that I have a huge amount of expertise on. But my comment is the same. If you have an order out of a Scottish court, doesn't matter where you go, that order is going to follow you.
Okay, just out of curiosity, I want to know, so how would that order follow? So let's say you've got an order, let's be this family court, it's Mickey Mouse court, right? Yeah, they've got an order against you in Scotland. You flee to England. I mean, how can they pursue it?
It depends on the circumstances. If it's just you running off to England on your own, and obviously you've not taken the children with you, then to be honest, the court's just going to ignore you, depending on assuming that we're dealing with a family matter. But if you have left Scotland and taken the children with you, you then potentially are starting to stray into an area that we call child abduction.
Okay, then, right, I guess if other than the child aspect of Scottish family law, everything else is slightly not so serious. I think the child abduction and the family court in Scotland that's when I presume it will get serious, obviously. But anything else is like they'll have to chase you and hunt you down. Yeah. Not as serious, obviously. That's what I'm presuming.
Yes, yeah. As I say, I mean, courts are very limited resource. So, is a court going to chase you hundreds of miles across the border to deal with something trivial? No.
Right. Okay. Fair enough. Bear that in mind. Right. Maybe I should run to Scotland. Maybe I should go to Scotland.
No, you don't want to go up there. You wouldn't understand a word they say. They wouldn't understand a word you say. That would be the issue.
Right, let's get back to the subject. Right, next question. Background. 2-year battle resulting in 50-50 live with order. A second 2-year battle to result in settlement where I keep house and she gets a settlement. Now mother refuses to accept she's not the main carer and extortion via CMS. Should I apply via Form A, or is my recourse only via CMS mandatory and first tier tribunal?
Right.
Can you
Okay.
bring that one up on your screen just so you can make more sense of it?
Yeah. No, I've got that one. Okay. I'm a little confused. Well, obviously there are two issues here. There's two sets of proceedings that we're talking about. There's a child proceeding which resulted in a 50-50 lives with order. Wonderful. And then there appears to be a financial proceeding which results in a settlement where somebody gets to keep the house. So I presume we've got two sets of proceedings. Now, I have a confusion because if you have a 50-50 lives with order, child maintenance service, CMS, should have no involvement whatsoever. Because
Exactly.
they regard that if you are 50-50 sharing the children, you are 50-50 sharing the costs. Because when the child is in your care, you're paying for it to be warm and fed and entertained with Netflix or whatever. So CMS aren't involved in a shared care or 50-50, call it what you will, order. So that confuses me a little.
Can I say something on that, Dan? I know
Yeah.
many cases, I've spoken with many fathers where they have 50-50, but they still consider, unfortunately, mother as main carer. So even though you have 50-50 shared care, they still consider one parent, 9 out of 10 times mother, as the resident parent, and father still has to pay some. I have heard this on many, many occasions now. So there is an element to that.
Okay, all right. Well, I would certainly be challenging that with CMS. So I have had occasions where occasionally I stray into the CMS arena, but I have had occasions where I've had to battle with CMS in order to have a shared care order or a 50-50 order fully recognised, in order that they, embrace the fact that the two parents don't require them to be involved. So yeah, and taking on board the comment about mother, yeah, there is a presumption, wrongly, but a presumption in this country that mother is naturally the primary carer for children, and so CMS do take a stance whereby mother is naturally the person they're going to try and support in a conflict, and that's not always the case, and it's an attitude that we really do need to change fairly quickly.
Okay, perfect. And his last part of his question is, or is my recourse only via CMS mandatory and first tier tribunal? Was that?
I mean, obviously, you again with CMS, just as with the family court, you have the opportunity to appeal, and in CMS it is a tribunal process, but to grab the process, it's there for you to use. If CMS are not being sensible with you in your particular matter, and you're just feeling that you're banging your head against the wall, then trigger the tribunal process. You'll often find, and I have this from experience, you'll often find that CMS suddenly have a change of attitude because they don't want tribunal, primarily because they haven't got the resource to deal with it. So you may find that that they sort of suddenly adjust their position for you, but take them down the tribunal route. You have that right of appeal, so use it.
Right. Next question. When the child is 16, can the CMS money be paid directly to the child and not mum?
There's no mechanism. There's no mechanism for that currently. There is well, for a start, a child arrangement order in the court stops when the child is 16, unless you've got an order that specifies beyond 16. CMS tends to involve themselves until the point where the child has left full-time education. So often that can go beyond and go into college and indeed university, and you're still involved with CMS in some instances. It needs to be an agreement between you and the other party as to whether you can pay directly to the child instead of paying to mum or dad.
Right. Next question. This is a good question because it's about those DV type of courses, which there's a lot of issues with currently. Hi, can I ask how much the shift program costs and how long the course is? I can't seem to find much on it.
I'm assuming that this is a DAP, Domestic Abuse Perpetrators Program.
Something along those lines, I'm presuming. Yeah.
There is a world of confusion around DAPs currently, and has been for the last 18 months. And I'll sort of quickly give you the history. CAFCAS used to have their own DAP. They used to have a domestic abuse perpetrators program that anybody who had been into court and had been found guilty, in inverted commas, of domestic abuse was instructed to go and undertake that course. And it took about 27 weeks. In July 2022, the Ministry of Justice decided that they couldn't afford to pay for it anymore. And so they advised CAFCAS that they were withdrawing their funding for the DAP. At that point, CAFCAS went into free fall, and they have stayed in free fall ever since. So we have an interesting situation now because CAFCAS do no longer have a DAP. The other problem that we now have is that CAFCAS will no longer recommend anybody else's DAP because they don't want to be criticized in case it's not a very good one. So lots of companies who used to provide private DAPs or independent DAPs, domestic abuse perpetrator programs, have now stopped doing them. And over the course of the last 18 months, since the Ministry of Justice withdrew the funding, lots and lots and lots of the domestic abuse perpetrator program courses have disappeared completely because they haven't got any funding for them, because CAFCAS are not recommending anybody to go on them, and because those course providers are nervous about having their course slammed or rubbished by the court to say that it's not good enough. Now, I will give you two very live examples of this. I have two matters currently which are still ongoing, where two individuals who are clients of mine both undertook independent DAP courses. One lasted 26 weeks, one lasted 29 weeks. We went back into court, having completed the two courses, and said to the court, here you go. You asked us to complete this course. We've done it now. Now we want to move to the next stage of this process and get back to finding some access with our children. And in both of those instances, the court said, your course isn't good enough. We don't accept it. As far as we're concerned, you haven't done anything. Go away and find another one. So it doesn't surprise me that you're struggling to find a domestic abuse perpetrator program, because there are very few in existence, and there are very few that are still active. A lot of them, to answer the question about costs, a lot of them that are still floating around are free, providing you can show them some court documentation where it's been suggested that you should do it. There are some, obviously, that are paid for, and the problem we have with paid for courses is that you take that back into court, and court says, I don't like it. I don't like the course. I don't recognise the course. So consequently, I'm not going to. We're not going to say that you've done anything. We're not going to recognise that. So I'm just picking up on another comment now. So that's what's happened to you. You've completed the course. Okay. So you've completed the course. They've said it's not good enough. All right. So yes, there we go. This is happening time and time and time again now. You are being sent off to complete a course that you have struggled to find, because it's like trying to find hen's teeth. You've struggled to find it. You've completed it. You then go back to court, potentially 6 or 7 months later, having spent all that time dedicating your time to the course. And then the judge says, I don't recognise it. I don't like it. I don't think it's fulfilled the objective. So consequently, as far as we're concerned, you haven't done anything. And you need to go and try and do it again. And you go and lose another 6 or 7 months and try and have another go. This is the frustration in court at the moment. It is being recognised by the court. They are realising that they've got a major problem here. They've ignored it for 18 months. But now I'm certainly finding I am now having conversations in court where I am saying, along with barristers who are representing the other side or solicitors who are representing the other side, but we are on one voice on this subject, where we are saying to the judge, there are no DAPs. There are no domestic abuse perpetrator program. You cannot rule that this man or this woman has to go and attend a DAP because there aren't any. So you, as the family court and as the Ministry of Justice and as CAFCAS, need to decide what you're going to do. And you need to do that quickly. That matter still hangs in the air, and it is a frustration for all of us.
Right, let's move on, as these comments and questions are coming in hard and fast. Let's try and get for as many as possible. Also, there's 36 of you in the chat. Please make sure you hit the like button. Thank you. Right, next question. How do you address combat allegations of parental alienation? Unfortunately, my kids report that maternal family are abusive. When I approach X, she says it never happened. What do we do with that?
Right, parental alienation. Let's for those who aren't familiar, let's describe what parental alienation is. Parental alienation is where one parent targets the other parent and turns the children against them. And they do that in a number of ways. The more sinister ways they are doing that is they are indoctrinating the children by using what we call false narratives. So they are telling the children, when you were a child, and you won't remember this because it was when you were young, your dad or your mum, whichever party that they're choosing to turn against them, used to hit you, used to sexually abuse you, used to neglect you. And they keep telling them that story time and time and time again until eventually children with susceptible minds, children start to believe. They start to accept that false narrative as the truth. That is parental alienation. Parents who say to their children, let's not call mum anymore if it's mum who's being alienated. Let's call mum Julie, because that's her name. So let's refer to her by her name. Or better still, let's call mum bitch, because we all know that mum is horrible, don't we, children? And they build and build and build on that animosity in order to turn children against the other parent. Often, and in fact, no, not often, 99% of the time, that other parent has done nothing wrong, aside from the fact that they potentially left a relationship that wasn't working for them anymore, and the parent who has the children didn't like it, didn't agree with it. And so they are teaching them a lesson, they are punishing them. So that is parental alienation. So let's go back to the question. How do you address and combat allegations of parental alienation? It is the most difficult thing in family court, is dealing with parental alienation. And there are a number of reasons why. The single biggest reason why parental alienation is difficult in family court is because the family court does not accept the fact that parental alienation actually takes place.
Right, let's move forward. Are there courses for parents who are separated outside of CAFCAS to help develop parents and co-parenting? And can mum christen the child in church without dad's consent?
Okay, right. Two questions. Are there courses? Yes, there are lots of courses available on the internet. I always tread carefully when you're buying courses off the internet because some of them are just complete rubbish. But there are lots of courses available via the internet about how parents can work together and how parents can co-parent. So it's just about a matter of researching and finding some decent ones. And you might want to go and associate yourself with some of the family-based charities like Women's Aid, like Refuge, like Crisis, because those are elements, they tend to have a training wing that often has some really good courses within it. So that's where you want to go searching for that. Can mum christen the child in church without dad's consent? Well, I suppose there's two answers to that. Legally, there is an issue with that. Practically, if mum decides to go to church this weekend and dad doesn't know, how's he going to stop it? So it's a difficult one, and the problem we have is because the church the church obviously is a world unto itself, but regardless of which church we're in, the church isn't necessarily going to have the processes that says, well, I need to talk to both parents before I do anything. Some will, some diligent vicars or imam or whatever will, some won't. That's a difficult one.
Yeah, I think you're right. I think the issue is logistical. If you don't know something, how do you stop something you don't know is going on? That's the problem, and that's what a lot of fathers or non-resident parents are facing, is the logistic issues of being involved in their children's life, unfortunately.
Yeah.
Right, next question. This question, Dan, let me give you a bit of background on this. There's some ethnic communities and whatnot, as you are a man of the world, a very multicultural person, you understand, there's black magic and all sorts of stuff like that goes on in other communities. Now, so the question is, if my in-laws believe in witchcraft, black magic, all the dark arts, let's just call it the dark arts, witchcraft, can that decide if I can get full custody on 5-month-old daughter due to it being a dangerous environment? These people are involved in the dark arts, mate. I mean, spooky stuff. Yeah. How does the court deal with that sort of ethnic spooky element to family court? Let's just cover that.
Okay, let's cover that, because I say that covers a whole series of issues, doesn't it? That covers a whole series of interesting life choices. I'll use that phrase. I have, so I'm going to go from experience, because a number of years ago I had a very, very real case. where the mother was involved in not witchcraft, but she was involved in hating witchcraft. She had an almost obsessive, and it was a number of years ago, so I'm comfortable to talk about it in broad terms. She had an almost obsessive hatred of witchcraft as a result of her faith. So the children were indoctrinated to the most bizarre degree. And let me give you an example. In one of the health shops, and I think it's still sold, in one of the health shops in this country, there is a chocolate bar, which is a vegan, no sugar, no milk, no anything chocolate bar. And it's called Wizard. That's its name. Mother went into a shop with the children, spotted this chocolate bar, took the entire box off the shelf, went outside in the street and threw it across the floor, screaming and shouting. So, because it's witchcraft. So, how did the court deal with that? What happened was we flagged it in the court that we had some issues. We had some extreme views. We had some extreme practices. The court actually moved the matter outside private law. Family law, predominantly all family law, i.e. two parents fighting over their children, or two adults fighting over their finances, is what we refer to as private law. It means that the matter is a private dispute. It's nobody else's business except the two people who have brought the argument to court. If the court believes that a matter is in the public interest, that it actually resolves it, because there are wider issues than just the argument between those two people, they will move the matter from private law to public law. When they move the matter to public law, CAFCAFs invariably fall by the wayside. They only tend to deal with private law matters. And the local authority, social services, then get involved. So to answer your question in terms of what can you do to get full custody of your child, you've got to get this matter into court. You have got to ask the question, or you've got to raise the allegation in court that there are issues around the black arts, to use Farouk's phrase, and you need to flag those as a significant issue, as a safeguarding issue on the child. The court will take that on board. They are highly likely then to elevate the matter to a public law. They will then involve social services. Social services will then undertake either, and I'm accelerating and I'm racing a little at this, but they will either undertake a section 37, which essentially means that they investigate the two parents to see if they are fit to be parents, or they will undertake a section 47, which means they will commence child proceedings to remove the child from the care of those parents and put that child into care. Get the matter into court, raise your concerns, and they will elevate.
Right, okay. But would that put father in this scenario in a favourable position? Say if mother's family is engaging in the dark arts, the black magic, whatnot, if it will favour the father. Father's no longer, say, living with them, whatnot. He's the non-resident parent. That will favour his position, won't it?
Of course it will. Yeah, of course it will. Father is the paternal side of the family, and if the maternal side of the family, mother's side of the family, is conducting in preoccupation, hobbies, pastimes, bizarre beliefs, the court will take father's side and say, well, look, you are clearly the one who is here to safeguard the interests of this child.
Perfect. Right. I hope that answers a question for that father. I think I know him. I hope this answers a question for him. Right. Next move on. There's a comment here. Can I sue the ex for loss of joy and happiness because I have not seen my children for 4 years? I think if that law ever comes out, let me know. Yeah, I'm right behind you. We'll put the application in.
Yeah. I'll answer the question very quickly. Can you sue your ex for loss of joy and happiness? No. If you haven't seen your children for 4 years, you need to commence court proceedings and get that matter resolved.
Right, next question. If you've been through court once, had fact-finding, all weighed against you, court told you go away, when you reapply, will they want fact-finding again?
In the court, you had a fact-finding. So all of the allegations went against you. Is that what we're saying here?
That's what I'm presuming, yeah. It went against him. Court told him to go away. Okay. If he reapplies, I presume for another application, will they ask for another fact find?
The court can't revisit allegations that they've already judged on. Okay. In law, we call that res judicata, which means you can't revisit a matter that you've already made a judgment on. So if you've had a fact finding and they've raised 10, 15, 20 allegations and they've made a judgment on those allegations, when you come back to court, they can't then bring all those allegations back and say, oh, guess what, we'd like these raised again just to block him again. The court has ruled on those. They are history now. They're gone.
Right. Okay. Good. Right. Next one. How much does it cost for bringing a child arrangements case to the High Court? Why does the High Court look at cases with a different angle and different jurisdictions?
Where are we? How much does it cost to bring a High Court? That one. Yes. Okay. Bring a child arrangement to the High Court. All right. High Court is expensive. Let's not kid ourselves. You only go to High Court once you've been through family court. There is, having said that, there is a set of circumstances where you can go direct to High Court, but it tends to be matters that have an international flavour to them. So if the children are in one country and one parent's in one country's perhaps in the UK and the children are somewhere else, Poland or Pakistan or wherever, you can then involve High Court from day one. But ordinarily, you've got to go to family court first, and then you make your way up into High Court if you're disgruntled or not satisfied with what has happened in family court. High Court, as I say, just when you do eventually get there, High Court is expensive because there are rules of engagement in High Court that don't apply in family court. Invariably, in order to survive in High Court, you're going to need to take a barrister with you. Barristers, for those who don't know, are the individuals who, in criminal court, are sat with a wig on and with a gown on, looking the part. Okay, those same individuals also work in family court and in family high court. They are obscenely expensive. You can pay anything between £1,500 and £5,000 a day for a barrister. But if you go to High Court, I will invariably, and we spend some time dealing with cases in High Court, but I always recommend to my clients that we need to get you a barrister. And there's a way of doing that, working with me and gaining a barrister, but that's a conversation for another time. But yeah, so High Court, you can get there, but you need to be international in order to get there direct. Family Court is your first point of access.
Right. Just move along. Quick question. How does 50-50 care arrangements work?
The 50-50 care arrangement works entirely upon the circumstances of that matter. I can't give you a stock answer as to how it works. What 50-50 means is that the court has ruled that neither parent is the primary. Both parents have absolute equal status. It's then down to the parents, which you can do in court before you leave, to work out how 50-50, what 50-50 looks like physically and practically day to day, i.e. who do the children live with during the week. If the parents live around the corner from each other, you can physically split the time. You can spend half the week with one parent and half the week with the other, because that's not going to impact on the children's school, because the school's in between you. If you can get that scenario, that's wonderful. But more often than not, the two parents have moved to either sides of a town, or indeed either sides of a country, and the children have to decide which parent they're going to live with Monday to Friday in order that they can go to school. And then how do we deal with weekend time? So it's entirely driven by the circumstances of each matter. It's very difficult to sort of give you a stock answer as to how 50-50 works.
Right, just want to put it out there at this point. If you do want to hire Mr. Daniel, as you can see, he's quite competent. He's been in this game a while. We are known as a dream team at the Royal Courts of Justice. We are the dream team. We come up with a game plan. I tell you how to function on the streets. He'll tell you how to function in court. If you want to hire him, look, drop me a message on disqualified.dads@gmail.com. The email address is in any description on any of my videos. Drop me an email and we'll hook you up. We'll get your case looked at and get you moving forward. Right, next question. A CAFCAS training course is mandatory requirement or another tick box exercise to please mum?
If it's in the order, if you've been directed in the order to complete a CAFCAS training exercise, regardless of whether it's a parenting course or whatever, then they are mandatory. They are mandatory. But I appreciate that there's a second stage to that, because in order to get onto a CAFCAS training course, you have to be referred by CAFCAS. And often you will sit in court with CAFCAS, and CAFCAS will say, well, we think it's a good idea for mum and dad to go on this parenting course, which you do it separately, you don't do it together. So then you'd all leave court. Cafcass then forget about it because they've moved on to the next case and completely forgotten about you. And then months go by and you've never seen the referral that you need in order to, the link you need in order to be able to get onto the training course. That's frustrating. That's one of the issues with Cafcass as a result of the volume of work they're having to undertake. And it's just about chasing. But I appreciate the frustration. They are mandatory if you've been instructed to take one. Getting onto it is often not as straightforward.
Right, next question, Dan. As they're coming in hard and fast, so I'm just going to reel them out as quick as I can. Can I sue a family court judge for not following the law, not notifying me about the final hearing, was forced to attend and did not receive any bundle from the mother? Still, the judge ruled against me.
Okay. Not getting no notification, and I'm going to pick this question apart. Not getting a notification about the final hearing is not the judge's problem. That's not his job. That is the court's job, for them to advise you. If you were working with a solicitor, and we don't know whether you were, if you're working with a solicitor, they should have received the notification and they should have advised you. There are too many occasions, and I sympathise with you wholeheartedly, there are too many occasions where the family court, not judges, it's nothing to do with them, it's an administrative function, where the family court is failing people by not advising them or not giving them sufficient notice of a hearing going ahead. I have had too many occasions where either I get a phone call to say, where are you? Because you should be here today. Or we turn up at family court and we get told that, oh yeah, we cancelled that 3 weeks ago. We forgot to tell you. The court is so swamped with the volume of work and there are just insufficient staff in place. They are breaking. They are breaking at the seams. And the system currently is just not working. And that's not fair for you. It's frustrating for me because I'm in there 4 or 5 days a week. It's not fair for you as a party in that matter. The judge made a ruling against you. You were forced to attend. Well, yes, you didn't know. You didn't receive a bundle. You should have received a bundle. You're legally entitled to receive the bundle that gives you the notification of the documents that have been in place, that have been submitted. I'm assuming, and you know, I may be wrong, but I'm assuming that you went on your own to this matter, because had you gone with legal representation, I would have expected, be it a McKenzie friend or a solicitor, I would have expected them to deal with that issue, to object in the strongest terms, and possibly to seek an adjournment. If you went on your own, you are often, sadly, in terms of the family court, a lamb to the slaughter.
Yes, I just want to highlight at this point for those that are aware of my situation. Like I said, 2 years, I had a non-mol and an occupation order, which effectively ran for over a year and a half, and the order in the end ran out before I could represent myself or before I could challenge it. And like I said, I was effectively living out of a van off grid for 2 years. I mean, but the key is, look, many things could have happened in those 2 years to jeopardize everything. So I'll just remind all again, going through the system, your biggest weapon is patience. Patience, keep a cool head, stay composed. You're in the trenches. You just got to keep chipping away slowly in the background, but you need patience. Right, next question. I think Imran's still going on about these divorce applications. We're not going to address that. Imran, just, you don't have to spend any money. What Imran wants to hear is, does he have to part with money? He's just a typical South Asian individual. You ain't going to spend any money. Just stop it now. Right. Next question, Dan. Just to quick confirmation, just to confirm, parental alienation is not recognised by the UK family court system. Yes or no?
The UK family court system is reluctant to recognise the phrase parental alienation.
Right. Next question. I have an allegation against me in fact find, which already been disproved by police. Mother admitted to police she lied. In your experience, can family judge still find me guilty based on FC rules?
Yes.
Right. Okay.
It's as simple as that.
Right. Ex-partner is in contempt of court for breaching undertaking order and continuously to breach interim child contact order. How will family court respond to this?
The family court will be critical. The family court has an opportunity, if somebody is repeatedly breaching an order, regardless of what the circumstances are, the family court has the opportunity to attach a penal order to your child arrangement order. What a penal order is that if somebody breaches it, you contact the court and say they've breached the order again. The court enacts the penal order that individual who's done the breach is immediately brought back to court, and often that can happen within 24 hours. And then they're either going to get fined up to, I think it's up to £10,000. It might be £15,000 these days. So they're either going to get fined, or they have the potential of losing their contact and have it removed altogether, which has happened on a number of occasions that I've been involved in. Or worst case, and this is real, worst case, they get sent to prison. There's no trial. There's no thinking about it. I have had two situations, only two, but two situations, because it's very rare that this happens, in the course of my years of doing this, where a parent turned up to be challenged on a penal order, and the judge said, I hope you brought a bag because I'm about to send you to prison. And they went then from the court to the custody cell to prison. One spent 7 days, the other one spent 14.
What mother? Just want to clarify, they sent mother to prison, yeah?
One was a mother, one was a father.
All right, it's 50-50, but they will send, it can happen, they will reluctantly send mother to prison if it comes to it, yeah? It can happen.
Yeah, so securing, so if you've got a partner who's, as I say, who's currently in contempt and breaching the order, your legal team, or indeed yourself, you need to be asking the court to attach a penal order, that's what's referred to as a penal order, to your child order. And
right, gotcha. Right, so fathers, there's one father I know actually, he's challenging a lot of these, what do you call it, mum's breach of orders and whatnot. So it goes to show, just keep chipping away. They want you to give up. Don't give up. Stay patient, stay cool and composed, keep chipping away. Don't do nothing stupid. This is what they want. They want you to react, get angry, react, overreact, do something stupid. It jeopardizes your position. So don't do that. Right. Mr. Ryan, next question. Bring it up on your screen. It's 9:16 p.m. I won't mention the name, but it says that the time next to the question, the name is 9:16. This is quite a technical question. I'll read it out, but you might want it in front of you. In finance, if pension is equal to or greater than 100K for one person and got basic CETV from pension provider before FDA, will the judge order for PODE analysis at FDA, or will it move to pension offsetting with CETV value? Does that make any sense?
That does make sense. It is a very technical question.
Definitely.
I'm almost inclined to say that's one when we start live streaming purely about the world of divorce and finances. There's not a straight answer. It's what pensions and the division of pensions and the splitting of pensions and a judge's stance on how to deal with a pension is on the day, driven by all the other circumstances that surround it. It's not just dealing with the pension in isolation, dealing with all the other circumstances that surround it and dealing with how the judge feels about it. So there's no straight answers to that. And certainly not an answer that I can conjure up without knowing more detail at this point. Yeah,
look, drop us an email if you want us to go into it further. Drop us an email. We'll arrange a phone call, maybe a consultation, and maybe Dan, you can go into it a bit further then if you would like. So just drop me an email at disqualified.dads@gmail.com, and we'll arrange a call between you and Mr. Ryan and see if we can work something out, or if we can get you some sort of answer. Right, next question. If ex-partner is in contempt of court, could it jeopardize her chances to relocate with the child?
Yes, if a parent is annoying the court, is in contempt of court, is breaching an order, it does jeopardize their future relationship with the court, and also jeopardizes what it is that they're ultimately trying to do. So essentially, the rule is play along with the family court as best you can, and they will give you some support. Challenge the family court, and you'll find very quickly they will come down on you like a ton of bricks. So that individual, obviously we don't know the detail, but that individual, yes, potentially is jeopardizing their chances if they are ultimately trying to relocate and secure the court's permission to do so.
Right, next question. Are McKenzie friends only for child cases, or can they also do financial remedy?
It's entirely driven by the McKenzie friends. Some of us tackle child cases and financial remedy, which obviously we do here at McKenzie Behalf. And we also deal with domestic violence and a bit of civil work as well. Some McKenzie friends will only focus on just child work. So it's entirely driven by the McKenzie friend you contact. And their capability is also entirely driven by them as an individual, how long they've done it, what their mechanism is, what their infrastructure is.
Right, the next one's not a question, it's a comment, but I know the chap, so I'm going to read it out because he's an activist campaigner for the rights of men and boys, Sean Buchanan. His comment is very interesting. I did this, it still didn't work. He underestimates the gynocentrism of social services and the effects of parental alienation. Shout out to Sean, follow him. He just started his YouTube channel. Next question. What about European Court of Human Rights infringement of Article 8 right to family life for the child to see their father and the father to see their child and the right to a fair hearing? I don't know if that's a question or a comment, but if you can comment on that, Mr. Ryan, quickly.
We can comment on that. There is. Let's do the fair hearing first. There is in the Family Law Act and also in the Child Act, the very first statement in both of those is what we refer to as the overriding objective, and what that says is that both parties are entitled to be treated fairly, equitably, and on an equal footing. So neither party should be disadvantaged in court. Now, in a real world, I need to tell you now, that doesn't happen. In a real world, if you turn into court with the most expensive barrister and the most expensive solicitor that you can find, and on the other side of the room, there's nobody except the parents sat on their own, how can that ever be fair? How can that ever be equitable? Using a McKenzie friend, we endeavour to try and level up that playing field a little bit, but I also have a major issue with the whole principle of overriding objective, because the reality is he who can afford to pay will always have the upper hand. Let's be aware of that. Let's deal with the other issue, which is Article 8. Okay, Article 8, which means under the Human Rights Act, which says that you have the right to a family life. That article is enshrined in family law, but it is ignored if circumstances suggest that should be compromised in your case, because there are allegations of domestic abuse, because there are safeguarding issues revolving around the children. So, yes, it's important, but it is painted in a slightly different way, governed by what it is that the court sees as your set of circumstances.
Right, let's move along. Are you done with that, Dan? Yeah.
Yep, thank you. Yeah.
Right, quick shout out to Rizzles 1985. Done a podcast with him. He's a model, actor, celebrity. Shout out to Rizzles. I love you too, Rizzles. Next question. Any mediation services worth engaging with? All seem to be run by feminists.
Interesting comments, and I get where you're coming from. Mediation services, my view is this. The court requires you to engage with mediation before you can actually go into court with an application. The reality is, if you could sit in a room with your former partner and strike a sensible deal, you wouldn't have been entertaining court in the first place. I think mediation is fast becoming, certainly in terms of court applications, it's fast becoming an almost pointless exercise. And it's just a cost, because it's going to cost you anywhere between a couple of £100 and £500 or £600 to engage in mediation. Taking your comment, are they run by feminists? A lot of mediators are women. That doesn't mean it's right or wrong, but a lot of mediators are women. Having said that, there are also a lot of male mediators around that I know. But my view is mediation has a value, but unfortunately, by the time a couple who are heading to court get into a mediation room, it's too late. The moment has passed.
Right, next, you done with that, Dan? Can I move on?
Thank you, yeah.
Right, next question is, now this situation is delicate, and I understand these scenarios and situations and logistically how difficult they are. So basically, this chap, he has his belongings still at the ex-in-law's house. How does he go about getting his stuff out of there?
Well, the start is trying to have a reasoned, civilized conversation with somebody, maybe getting a middleman to act for you in order to try and secure your property. If that doesn't work, either through you talking to them or somebody talking to them on your behalf, if that doesn't work, then unfortunately you are then starting to entertain whether it is you want to go down the legal route. That's not a family matter. That's not a family law matter, securing your belongings. I assume we're talking about clothing or furniture or whatever. That's not a family law matter, unfortunately. That's a civil matter. And you would have to go through the civil court in order to do that.
Okay, I just want to touch something on that, Dan, because look, there's something we need to cover here as far as getting belongings and stuff is concerned. And as you're aware, of my own situation, and now I've spoken to many fathers, and the situation, there is a pattern where, relationship ends. There's this logistical issues. Mum then seems to arrange with the police to come collect belongings. Now, this has happened on many, many occasions, and this is a pattern. And I want everyone to know out there how this pattern works. What happens is mum arranges with police, will pick up some belongings. Police sort of say, yeah, we'll be present to make sure nothing gets robbed. And one occasion, I even know a father where the police assaulted the father, and the locksmith that the police brought along, they headlocked and tried to do a sleeper when he got choked. They choked the father out. The locksmith that was with the police even joined in on the action and choked poor father out up in Manchester. Manchester police did that, right? Now, they seem to turn up with these heavies, and also the police who stand there and sort of watch this and get involved in the action. They seem to strip the house of all belongings. Yeah, no one seems to check what belongs to who. There's no receipts to be produced. And as you know, mine was done by these chaps from Iman Channel. They are a TV production company. They're these practicing brothers that all came to my house. Not one question asked. We have CCTV footage, like I said, which we've seen and we are pursuing, where they removed all my furniture, including the toilet roll. Right, and again, every father I speak to, it's so petty where they even remove the toilet roll out of the bathroom. Like it's pathetic, yeah. And there seems to be a consistent pattern. Now, what I've said to fathers, what are fathers to do to try and counter this? There has to be some legal position where, when they turn up with the police to say we're here to collect a few belongings, they rock up with 4 or 5 lads, all these heavies, and the father, he seems to be powerless. So if he's not there, they just do what they like. And when he is there, he just gets either held down by the police or railroaded by the ex's family. Like, I keep hearing this. We need to do something about that.
Okay, let's start by understanding what the role of the police is in that scenario. So the police turn up along with, we'll use your example of the former wife, and she brings half a dozen mates with her and 6 vans, and they rock up outside your house. The role of the police is to keep the peace. That is their only role. They're not there to referee or mediate or decide what can or can't leave the property. So if mother, using this example, if mother decides that what needs to leave the property officer is absolutely everything, including ripping up the carpets, the police will just stand by. Their only role is to ensure that the peace is kept and there is no disruption. That is their role. Outside of that, they have no jurisdiction. There are lots of examples where this is being done, and it's not just mothers turning up; it's also fathers turning up and clearing a house out. But there are lots of examples of this being done, and people say, "Well, the police turned up and they did nothing." They did nothing because it's the issue of removing property from a marital home is a civil issue. It is not a criminal issue. Their role is just to ensure that a fight doesn't break out. The issue of I am taking property from this house. I own this house. I part own this house. I used to live in this house because I'm one of the former partners. I'm the ex-wife. I'm the ex-husband, whatever. The police aren't interested in that. Police aren't interested. Literally, they will stand by and watch while you take everything, as I say, including ripping up the carpets if that's what you choose to do. They will not object. I've had a couple of occasions where, and it was a father in both cases, where the father has said to the police, well, at the very least, we should be allowed to list what they're taking, so that at some second stage, at least I can say, well, hang on, they've taken all of this already. And in both of those instances, which were a good couple of years apart, the police said, it's not our job. Well, but can you slow them down so I've got a chance to make a note? No. So the police aren't interested. There's nothing to do with us. Our role is just to ensure a fight doesn't break out.
Okay, so what is father to do?
It's a difficult one. It's very difficult. If you're facing a partner who's taken it upon themselves, whether it's father or mother, who's taken it upon themselves to empty your house out, whether you're there or whether you're not, it is a civil matter.
Okay.
The best thing we recommend is, obviously, invariably you become aware of it because one of the neighbours rings you and you're at work and says, oh, by the way, it would appear you've got a removals company outside your house currently. The best thing you can do is, rather than go down there and kick off, because as you're just going to end up getting arrested and spending a night in a custody cell, the best thing you can do is go down and just film it. And just film what is going on, film the people who are there, because then you will be able to use that later on when you come to financial proceedings and you say, well, here we go, here's the footage. When mother says, you know, I didn't take anything. Well, hang on a minute, because there's 6 fan loads here and there's 15 blokes who suggest otherwise.
See, I've got a suggestion, Dan, because look, some of this, like I said, this specific situation is a very grey area, and I've come up with my own, sort of idea of how to tackle this. So look, first thing father can do, stand there with a camera, phone, body cam, whatever you want to call it, GoPro, and firstly record it. Secondly, mother seems to turn up with heavies who happen to be men. This is the situation where we need to exploit the bias in the system and society. So what I've said to fathers is ensure you are there. Do not feel ashamed or embarrassed. Ensure you are there and get as many female friends and family members as you can to turn up. And then surround the front door, surround the equipment. Because if these heavies then lay a hand on a woman, including the police, there will be serious backlash, right? Because you touched a woman, you put your hand on a woman, yeah? So I would say to fathers, at these exchanges, turn up with as many female members of your family, friends, colleagues, from the lady from the coffee shop, whoever, get load of them outside your house. Make sure they make noise. Make sure they cause a stink. They cause such a scene where police will just say to the heavies, you need to back off, get away. Because if you put your hand on any of these women, as far as I'm concerned, that could be sexual assault. That's harassment. That's assault right there on the woman. So I think that's what you need. And have your phones out, have your cameras out. And that is your only line of protection, is the females you have present on your side. I think that could be a way to negate some of this circumstances. It's the only way I see it.
I get that. All I will offer is a word of caution that says you are potentially guilty of inciting civil unrest. And potentially at that point, the police will step in and say, well, actually, we're going to arrest you because you're the one who's instigated this. So, yes, be careful.
But my point is, your female friends just happen to be there at that time to offer you emotional support. That's all. I'm not saying get anyone together. I'm just saying if you've got a female family and friends around you at the time, at your home, who just happen to be there because they're giving you emotional support because you're going through such turmoil and whatnot, you haven't seen your kids. That's all it is.
The police do not have a burning desire to arrest people.
Yes.
Because it's an awful lot of paperwork, and it gets in the way of eating chips. So they don't want to arrest people. So what they would more likely do in that instance is if they see a situation brewing, they will say to whoever it is who's turned up with a convoy of vans, they will say, today's not the day, come back another day, go away.
Exactly.
In order to diffuse the situation.
Exactly. Guys, take note, everyone. And some mothers who are in this situation, take note. Right, let's move along, Mr. Dart, Mr. Ryan. These comments just never ending. Right, now we've covered that. I think there's the same fella's got another question. I also have money that my in-laws have taken. How do I manage to get this back? It was via bank transfer. I think that's a bit of a long. I won't be able to answer that and needs a sort of consultation. Really, look, get in touch with me. I think I've spoke to this chap. Drop me an email, send me your documents. We'll look over it. And we'll come up with a game plan. Get us on board. We'll come up with a game plan. We'll show you how to navigate this. Another comment from Sean. Marriage causes right. Solicit and barrister a huge waste of money. No, I'll forget that. Let's move on. He's making a comment. Right, here we go. Currently in family court, I am the father. Ex-wife has a convicted terrorist sister and his brother. Oh, bloody hell. Right, listen, I'm not going to use some of these words. We don't want to get back. Right, I just want you to read it down. I'm not going to read. Just read it out.
Yeah.
If it's applicable or if there's something you can add. You know what I mean?
Okay, I'm just finishing reading it. All right. If you've got a set of circumstances where one party, we're kind of back to the black arts thing, aren't we? Really, where one party has got an interesting association or an interesting background. You really have the fact that you're suggesting that Kafkas ignored all of that and is worrying because the association of what you suggested would cause for me safeguarding concerns around the children, obviously because you're dealing with extreme views. So without knowing the detail, obviously, it concerns me that if Kafkas ignored all of that, because ordinarily Kafkas are actually very wary where members of the paternal family, or indeed the maternal family, have history that we should be concerned by. I've had a couple of occasions where one party has got perhaps a family member, like a brother or a sister, who's been to prison. Kafkas is all over that and saying we need to know why, we need to know whether they present a safeguarding risk. So if you're suggesting that somebody has got something as extreme as what you've put in the comments there, that would give me some concern if Kafkas have just dismissed that.
Right, let's move along, Dan. Let's try and complete some of these. Can judges kick out a McKenzie friend from the courtroom because they are not a solicitor?
The judge has the power to kick anybody out of court. I suppose the question is, how valid is a McKenzie friend? And that really leads us into the conversation of, good McKenzie friend versus bad McKenzie friend. If the McKenzie friend has a direct association with the person that they're alongside, because it's their mum, it's their brother, it's their sister, it's their best mate, the court often will rule that there is a conflict of interest and they will remove the McKenzie friend from the room. If the other side makes an objection, and it's a valid objection about the McKenzie friend, the judge has the power to remove the McKenzie friend. But usually, in my experience, and I'm going to say, obviously, I've been in court too many times. I've been removed from court once in, I don't know, in excess of 1,000 cases, probably once. And that was because I had a bit of a contretemps with the judge. We had a bit of a disagreement, and he opted that I should leave the court for that particular hearing. He limited it to one hearing, and I came back on the next one. But yeah, so they do have the power. They have the power to remove the McKenzie friend. They have the power to remove the solicitor if they want to. It's their room. When you walk into the court, the judge, you're in his playpen.
Right, Imran, if you want to come on live, there's a link on the chat somewhere. Click on the link, keep your mic or camera on, I can bring you on. Right, question again. Social services advised to stop final order contact, stating significant concern raised by kids through school. Then social services starts with section 47, but no reply for a few weeks. Can we raise C79 or wait for report? That's a good question.
That's a good question. If social services have already been directed to do a section 47, then your C79, which is an enforcement application, is probably going to fall on deaf ears. What I suggest you do instead is go to local authority who are conducting the 47 and say, I just need to make you aware of this, and share with them what it is that you would ideally have liked to put into a C79.
Right, quick question. Do you know what is the Oldfield McKenzie chap like? Do you know the Oldfield McKenzie chap?
I have no idea, to be perfectly honest.
Right, okay. Right, next one. What if a judge refuses to order the mother to reveal all her texts? Dad lists his phone. That's not fair. Dad says the text shows she was abusive or she's showing text out of context. Does that make sense?
Yeah, it does make sense. The whole issue of screenshotting, which is something that appears now in evidence time and time and time again, where one party produces a screenshot of a conversation that took place and the other party produces a screenshot of another conversation that took place in order to try and prove their point. Here's the problem. People, funnily enough, when they do their screenshots, tweak them, edit them, crop them, because there's comments in there they don't particularly want the judge to read. They want the judge to read the bit that said, stop it, you're being unreasonable. I'm trying my best for the children. That's the bit they want the court to read. What they don't want is the last paragraph where it says, if you don't behave, I'm going to come and give you a slap. That's the bit they didn't want to read, so they cropped that. Your job, if you're trying to refute that and challenge that, is you've got to be able to present the judge with screenshots that aren't cropped. You've got to be able to demonstrate the judge with transparent screenshots. And this is what that conversation actually looks like.
It goes to prove again, never have an argument over a text or WhatsApp, ever. So those in any relationships who are not going through this, do not have an argument over text, WhatsApp, or voice note, or anything like that.
Text messages will come back, and I'm going to use a phrase now, and I apologize if people don't like it. They will come back and bite you on the arse.
Big time. Right, okay. Quick question here for you, Mr. Ryan. Why doesn't Mr. Ryan go back to uni, study law for 2 years, and become a solicitor advocate? He will be the people's champion.
Because I'm too old. Because unfortunately, I'm just too old. I mean, I choose to do this alongside my various other business interests because I think we provide a service to people. If I wanted to become a solicitor or indeed a barrister, I'd have done that years ago, but I didn't. I was doing something else at the time, somewhere else. Now I'm just too old.
Right, okay. This case again, this chap, I'm going to read one of two of his comments and questions out. We don't have to answer it now. I would highly, I think I know this chap. You need to email me. You need to get in touch. We need to sit down, come up with a proper game plan. I just want to say to you again, you're at the early stages of your situation. This stage is vital, how you play your cards. You need to get in touch. We need to get Mr. Ryan on board and go through your case and come up with a proper game plan. I'll just quickly read his questions out, Mr. Ryan, if you can maybe touch on it. If not, we'll move on. My in-laws house their daughter-in-law. Who has been in touch, and she has messaged me. She's now being abused. Can I use this as evidence for my case against my in-laws? Now that I have left, she says she's been abused and abused physically. Should I wait for the court to use this or not? I mean, it's more of an in-depth, obviously, question, but I mean, would you reckon?
Yeah, if somebody's being, abused, be it physically or emotionally or psychologically or sexually, then we shouldn't be waiting for a court process in order to flag that to the authorities, whether that be the police or the local authority or social services or through a MASH reference. Don't wait for, if you know somebody's being abused, then don't wait, react.
Yeah, and unfortunately, I think Mr. Ryan just highlights that point again. There are genuine female victims out there of abuse who are not getting the help and support they need. And there are others who are unfortunately fleecing the system and taking away resources from genuine victims who we are there for and we do support. Right, there's another personal question here for you, Mr. Ryan. Has Mr. Ryan been through family court himself?
Yeah, I go through the family court 4 times a week. But have I personally had a case in family court? No. The reason I came to this arena was because one of my members of staff came to me many years ago and said, I'm in trouble. Can you help me? Because I can't afford to go to a solicitor. And I got involved, and then somehow along the lines I learned about being a McKenzie friend, and then I decided that maybe this is something we should do to help others. So my team, who work around the country, we provide a service that we believe has a value to people who either don't want to or can't afford to engage with solicitors. So no, I've never experienced the family court from being a party. I don't think that's to any detriment, because I've experienced more pain as a result of everybody else's case than I would want anybody to experience in their lifetime.
Right, Mr. Ryan, I've got a final question via WhatsApp. I'm going to read out to you. He wants to remain anonymous. It's a bit of a long one, but if you can make sense of it, answer it, I'm sure you might recognize the question as well. Okay. I'll just go for it. Right. I'm deeply concerned about the misleading of my case by the family court, despite repeatedly informing them of the mother's misuse of prohibited steps order and non-molestation order to alienate the children and cause harm. The court has failed to address the situation. They continuously postponed the fact-find hearing for 2 years, and when it finally occurred, the judge displayed bias and disregarded evidence of child harm, favoring the mother's requests. I've challenged this decision, but 6 months later, I'm still awaiting a resolution. Meanwhile, my contact with the children has been restricted to a contact center, and the mother continues to alienate and emotionally harm them. I urgently seek meaningful contact with the children before the final hearing in July, and request that the children's fact-finding take place before the final hearing. When I submitted grounds of appeal, I highlighted all those irregularities that the judge did during the hearing. However, when I received the transcript, it clearly showed that the transcripts have been forged and there are omissions in it. The judgment has not been sent to me. However, it's been 2 months since it was sent to the court. This is the 3rd time the court has postponed the appeal hearing, claiming that they have not received the judgment. How can we address these issues and ensure the children's well-being is prioritized?
Okay, I am familiar with this case, and obviously I know you are as well, Farooq. So I'm going to sort of tread carefully in terms of response.
Yes,
it is a matter that is currently up for appeal. There are elements of this case that are concerning in terms of how the matter has been conducted in the family court. Currently, there is a frustration because obviously we're waiting for the family court in order to hear an appeal. My view is that if we don't get some resolution on that over the course of the next few weeks, and few weeks is probably 3 or 4, I would probably be recommending to my client, if they were my client, that we start to entertain an application direct to High Court on the premise of procedural failure. So the family court has failed us, and we've now had to move the matter up to High Court in order to try and secure resolution there. It's complicated, it's obscenely expensive, but potentially that's where we need to take that matter, because I say it has a lot of elements to it.
Right, I think we have covered quite a bit. Apologies if I've missed any of the questions or comments. Thank you all for joining. If you want the dream team on board, drop me an email on disqualified.dads@gmail.com. Please like, subscribe, follow, and share. We will try and do these streams regular to get the information out there and to help people. Also, there's a PayPal link in the description or on the channel somewhere. Help support the channel, donate and sponsor via that PayPal link. Thank you all for joining. Mr. Ryan, any final closing comments?
Yeah, thanks for your time, everybody. It's the family court is not a fair environment. You need to go in there with people who understand how the procedure works, how the process works, and where the potholes are.
Yes, and guys, as you know, I coach a lot of fathers. I'm qualified in coaching now. If you want some proper professional coaching, tap me up. I am coaching and mentoring a lot of fathers through a lot of pain and trauma, and I am qualified in coaching as well. Also, just want to say, hang in there, stay strong, dig deep. You will be tested. It is a very difficult road. You need to hold it together. You need to hold it together. You need to keep going. You need to put your children at the forefront of your mind. They are priority here, not you, not your emotions, unfortunately, your children. So give it your best shot for the sake of your kids. Thank you for joining. Mr. Ryan, a pleasure seeing you again, and we will catch up soon.
We will.
Thank you all, and good night.